The Honourable David Parker.
Well, I have read the bill, Mr Speaker, and I want to address some of the issues that arise from it. First, today the irony could not be greater that we are discussing the harmful digital communications bill on the very day when the government will not answer allegations as to whether the GCSB was used to intercept the communications from competitors for the World Trade Organisation Director-General job, the rivals to Minister Grosser, whose emails, it appears, were intercepted by the GCSB in pursuit of a job application by Mr Grosser. That will have long-term consequences for New Zealand's reputation as an honest broker in the world. It will have implications on our trading relationships with countries like South Korea and Indonesia, and we've already seen, I think, some of the disquiet in civil New Zealand as to the consequences of those harmful digital communications. In respect of this bill, I think the first thing to say is no one in this House of Parliament is saying that some of the egregious conduct that we see through the internet, amongst other media, is acceptable. And so people who are criticising this bill aren't condoning that conduct. The second thing I would say is in respect of the roastbusters issues which have been referred to by some speakers in this House, let's not go too far down that line for two reasons. One, the report of the Police Complaints Authority showed that there were legal remedies that could have been used in respect of those individuals that were not used because of either incompetence or some other form of bungling by the authorities. It wasn't for want of authority that they didn't do anything, it was because they didn't do their job properly. The next thing I would say is that this legislation was given a kick along because of the Roastbusters controversy, and the Minister at the time was the Honourable Judith Collins, who was the Minister who conducted the bill. And again, I think with the benefit of hindsight, given what we've seen in respect of what we know of Judith Collins passing information to whale oil, which was a harmful digital communication, it's deeply, deeply ironic that the National Party is pretending to be protecting people from cyberbullying when some of the worst instances come from their own members, including the then Minister who was responsible for this bill. Mr Speaker, in respect of the offence that's created of causing someone serious emotional distress, the explanatory note, or not the explanatory note, the Select Committee commentary says that the term which is used is a digital communication which is caused or is likely to cause someone harm, and harm is defined as serious emotional distress. Nowhere in the bill is that term defined. The commentary then said, we consider the principles would provide a useful reference to help infer a common set of values when assessing whether behaviour was acceptable. How woolly is that? You then turn to the principles that we're meant to give us confidence that we're creating something that's reasonably easy to understand, and some of them are. Some of them, include a digital communication shouldn't be grossly offensible to a reasonable person in the position of the affected individual. I can agree with that. A digital communication shouldn't incite or encourage another individual to commit suicide. I can agree with that. But these aren't principles that have to be all met. Any one of them from the list can be met. Principle 5 says a digital communication, not a series of digital communications, but a digital communication should not be used to harass an individual. Well, if that's the test, if this law was in place when Judith Collins sent her email to Whale Oil and then Whale Oil used it to attack Simon Pleasance on the basis of the address disclosed by Judith Collins, Judith Collins would be in breach of a criminal law. Is that really what you're intending? To criminalise the likes of Judith Collins for her conduct? Because that's what this says. It doesn't talk about a series of harassing emails. It talks about a digital communication which is used to harass an individual. That would be an instance of a criminal offence that would be created, because I'm sure that that caused serious emotional distress to the person that was on the end of that. I haven't heard the Minister stand up and say that that's the sort of offence that's being intended to be created, because I don't think the Minister has thought it through properly. I want to refer to Principle 10. A digital communication should not denigrate an individual by reason of his or her colour, race, ethnic or national origins, religion, gender, sexual orientation or disability. Now, I don't like people doing that, and I don't think they should. But we don't have laws against hate speech in New Zealand. And if the Minister wants to introduce a law against hate speech, introduce a law and properly discuss the principles that should lie around whether we should have a prohibition on hate speech. Because we haven't got it in New Zealand, and if we're going to have it for digital communications, why shouldn't we have it in the newspaper? What's going to be the implication of this? When we have someone like the Sensible Censoring Trust or some of these other organisations in New Zealand who I think say reprehensible things, I think a lot of the things that they say would be caught by that principle. I know they routinely denigrate judges. They denigrate them as a class of people. I've heard them, some of these groups that are in favour of fathers' rights, who feel that they are abused by the criminal justice system, they abuse some of the judges on the basis of their gender, as if they are showing bias. That would offend Principle 10 if it went to the stage that it was causing serious emotional harm to people, and we don't know really what that means. Mr. Speaker, laws should be of universal application in principle if the principle is right. If we are going to have prohibitions on hate speech, they shouldn't just apply to the internet. It's a very, they shouldn't just apply to the limited situations here. We will have, if this law passes in this present form, the ridiculous situation that it would not be illegal for someone in a New Zealand website to host deeply offensive messages from the Islamic State people saying that the state should be overthrown, and anyone that's not a Muslim of their persuasion that believes in Sharia law is justified as being killed, and the state should be overthrown, homosexuals should be put to the guillotine, all of those sorts of things, they would be perfectly permissible under this legislation, because this legislation wouldn't cover that ill, whereas some of the other things that I have described would be covered by this legislation. Mr. Speaker, in the time that has passed since this bill was prematurely reported back to Parliament, under pressure from the then Minister because of the Roastbusters case, times have changed overseas. And I would call upon the government to reflect upon whether they are creating some unusual laws in respect of criminalising behaviour in the internet when we don't have general prohibitions against the same conduct under other laws. Mr. Speaker, we have written from the Labour Party to the Minister offering to meet to discuss some of these issues. I do find it deeply ironic that we are debating harmful digital communications, the nature of which would have been offences by the very Minister who introduced the bill, Judith Collins.
This is a split